Okay, well, thank you everyone for joining us today. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Really grateful that you take some time this afternoon to sit and listen to transition tips, maintenance mandates, and sales solutions. We have Ben Karb and Mike Hunter with us today with Offit Kerman to help lead us through this webinar. We will be taking questions throughout the session. So if you do have questions, please feel free to type them in the Q&A option within the Zoom link. We are also recording this session. So we do hope that you will share this information with your fellow board members. If they can't join us today, we do keep them recorded, all the recordings on our website at camsmgt.com. They're in the board members section under webinars. So we have about 22, 23 different webinar recordings there for you. And so we hope that you would check those out at your leisure. So Ben, I will turn this over to you and let you share your screen and get this started.
All right, let's see if I can do this.
Well, he's getting that going. I'm Mike Hunter. I'm Ben's partner. This is Ben's presentation. I told him earlier today that I was here only for color commentary and comic relief. So,
and I told Mike,
this is a very dry topic. So I'm going to interject a few good old classic one-liner lawyer jokes here eventually.
So, can you guys see the presentation on your screen?
We can.
All right. Well, we'll jump in. If we have technical difficulties, Ben Rhodes or Sydney, jump in and let us know. But it is a pleasure to be here with you guys today. We are attorneys with the law firm Offit Kerman. Let me show our pictures. Although you can obviously see us, here's me. Here's my contact information. I am licensed in North and South Carolina, and we'll be covering both states during today's presentation. We are here in Charlotte, but we are a statewide practice in both North and South Carolina. So we can pretty much help with any HOA or condo issues throughout either state. And I'll jump to Mike and let him introduce himself.
I'm Mike Hunter. I'm the founder and leader of the Community Association Practice Group at Offit Kerman. We were known as Horak Tally before that. I've been doing this kind of work for about 30 years, and for the last 20 plus years, it's been 100% of my practice. Hey, Ben, what do lawyers use for birth control?
I don't know.
Their personalities.
Sad but true. All right. So here's a bit of a roadmap for today's discussion. We're all honestly kind of covering a large part of the life cycle of an HOA, from really the transition of control from the developer to the members. There's a little bit of a different process for HOAs and condos. So we'll touch on both of those issues. We will also get into ongoing maintenance and some of the best practices for boards to keep in mind. We will also talk about a brand new topic for all of us, and it's specific to condos in North and South Carolina, but it is the new Fannie Mae Freddie Mac requirements. They sort of took all of us by surprise a couple of months ago, and we'll touch on them and what we believe are best practices. We will talk a bit about seller disclosures, things that sellers in both North and South Carolina have to disclose to buyers. And we'll then open it up to a little bit of case law. That's really not all that interesting, so we've only got a couple of cases to discuss. And at the end, we'll open it up to Q&A and comments. Mike, do you have anything to add before we jump ahead?
No, not really.
Okay. So our first topic today is developer transition. What we're really talking about here, the big event for a transition is the transition of control on the board of directors. That is really the big event for a transition. Some HOAs think that a transition is sort of this giant big event. But really what it is a series of events that culminates in the transition of control from the developer to the members. The law in both North and South Carolina allows a developer to retain control over the HOA until a specified date. And that date really can be, at least for HOAs, it can be when the developer no longer owns any property within the HOA. So it can occur really after it sold all the lots. Now, most developers don't wait that long, but it's possible. They could reserve the right to do that. And in most communities, the transition is tied to a certain threshold. As I mentioned, they could wait till they sell all their property, but usually there will be a provision in the declaration or in the master deed where it says that upon the sale of, say, 90% of lots, the developer will hold a transition meeting, at which point the members can elect a board of directors. It also includes several other key events, such as the transfer of common areas from the developer to the HOA. That's something that usually happens towards the end of the transition, although sometimes the developer will deed over the common areas rather early in the process because a developer doesn't really want the obligation of maintaining common areas that really are intended to be used by the HOA and its members. In some communities, you also have an architectural control committee, and sometimes it gets transitioned early, sometimes late, but it also gets transitioned from the developer to the owners. And Mike, do you have anything to add on this slide?
No, but I will say I have seen cases where developers, for various reasons, have wanted to cling to control of the common areas, even when the lots are either all sold or almost sold. And I never have understood that. I'm dealing with a case now with a community up in the mountains, and the developer has not deeded all the common areas or the streets over. There is a clubhouse that he wants that's supposed to be common area. The HOA is paying to maintain it, but yet the developer controls it and wants to use it as a private wedding venue and for special events to line his own pocket. The HOA doesn't get that money, so we're battling that right now. And the developer actually just got indicted on a federal tax fraud charges. So we'll see where that goes.
Oh wow!
But that's the exception.
Yeah. Well,
Hey, Ben, one question that pops up a lot is how involved should the board be in the conveyance of public streets or anything that is owned by the public?
well, that's a good question. And there's not a great rule of thumb, but usually the board is not really involved very much. What usually happens is the subdivision streets will be subject to either state or city approval before either the city or the state will agree to maintain them. Typically, the developer has to provide an engineer's report showing that the streets are up to a certain level of completion and really fully complete before a municipality will accept control over them. So really, the board doesn't have a whole lot of say in what happens. What boards sometimes want to do is to put pressure on the municipality not to accept the streets or to impose conditions on a developer to bring the streets up to a higher standard. And as a leverage tactic, sometimes what boards will try to do is convince a municipality to withhold a construction bond. What a lot of the municipalities do is they will say to the developer, you have to place a bond with us that if you don't complete the streets, we can call the bond and have someone else complete the streets and you don't get the bond back. In my experience, that is not usually a very successful way for an HOA to exert pressure. I've seen it happen maybe once or twice, but usually it's really the bond is a contract between the developer and the municipality, and boards don't really have a great way to enforce it or really to twist a municipality's arm and make them do something different. All right. So the typical process to transfer control from the developer to the members is, as I mentioned earlier, the election. What you typically see is there will be the first real annual election where the members get to elect every single director. It's really a very important event in the timeline of a community, because that really is where the developer is saying, I'm out of here. In most cases, as Mike pointed out, there are rare exceptions where a developer tries to retain control, but by and large, once you have this final meeting, the developer is out of the picture. In addition, once you elect the directors, the board then appoints officers. That's something a lot of boards don't understand. They think that the members are electing the president, for example. In reality, the members are electing directors, and then the directors appoint a president, a vice president, a secretary, and a treasurer, usually from within their ranks. Usually the person that sits on the board gets appointed as the president. Not always, but that's usually what happens. And in tandem with all of this, the board usually appoints the architectural control committee. So once your membership, your member comprised board gets elected, then they usually appoint the architectural control committee. On occasions, the board is the architectural control committee. So sometimes the directors wear multiple hats. What also happens is the bank accounts, the important contracts, everything that really governs the community, that really gets handed over to the new member elected board as well. And what you sometimes see right at the tail end of all of this is the developer records the common area deeds over to the HOA. Sometimes there will be a pool and a clubhouse, for example, that the developer has, and it gets deeded over as one of the last steps. So there's a whole series of things that typically happen, and those are the highlights. Mike, do you have anything to add?
No, but Ben, what do you call 1,000 lawyers at the bottom of the ocean?
I could probably say some things, but they might not be appropriate for the camera.
A good start.
Hey, Ben, you mentioned the developer turns the board over, and then you said, I'm out of here. But the developer is still going to have some obligations. Can you talk a little bit about the obligations to the community, even though they may not control the board?
Well, there could be obligations for the developer to the community, even after it gives up control. We'll touch on this in a couple of slides, but sometimes a developer will have to do something to the common areas to bring them up to a certain standard. Sometimes what you see is a pool may not be fully complete by the time the developer transitions control, for example. So the developer will be obligated to finish the pool. That's one of the types of maintenance concerns you sometimes see. Another one is that if the developer has, promised the community some other amenities, for example, they may need to finish out the amenities, all that sort of related. The developer also has fiduciary duties to the community, and I can touch on this in a few slides, but at least in South Carolina, we've got a very strong case, a case that went to the South Carolina Supreme Court, where a developer is obligated to either have the common elements in a reasonably good condition when it hands over control, or it has to have funded the HOA sufficient to bring them up to a certain standard. So we've got a very good case in South Carolina that tells developers, hey, you can't just turn over crappy common areas. So that's sort of a lingering obligation of a developer.
Yeah, and unfortunately, we don't have anything. There's nothing in North Carolina law. We don't have a case like that. There's nothing in the Planned Community Act or the Condo Act that really puts an affirmative obligation on the developer to turn over the common areas in any particular state or condition. That the statutes are just silent. I mean, but fortunately, most developers are conscientious about that. But we still, a couple times a month, we've got an HOA coming to us where the developer has pulled up his tent stakes and left, and they're finding all kinds of construction defects in the clubhouse the roads start crumbling because they didn't compact the soil or put down the gravel correctly or apply the asphalt correctly after the fact. And that can and often will lead to a lawsuit by the HOA against the developer and possibly the contractors, but it's not unheard of. That's why it's so important to have your engineering and reserve studies done before turnover. And Ben's going to cover that in a couple of slides, but that is critical.
Yes, it is. And that's definitely one of the best practices that we'll get into, because that is critical.
Mhm.
So in condos, at least in North Carolina, the turnover of control is a little different than in HOAs. By statute in North Carolina, the developer has to allow members of the community to go onto the board of directors at certain critical stages in the development. As I put on the slide here, once 25% of the units in a condo get sold, at least one director needs to be put on or needs to get elected by the members and put on the board. Once the developer sells 50%, you have to have a third of directors on the board. Now, the irony here is you can have a 3-person board. So if you have to have a third of directors, you could sell 25% and a director has to get on the board. But once they sell 50%, there's no obligation to put another director on because there's already a third of owners, of owner elected members on the board. Once the developer sells 75% of units within 120 days, the developer has to let owners take control entirely. So that's a very important milestone for condos. Interestingly, as I was researching this, and I'm kind of going to get nerdy here, but I've got a captive audience, so you're stuck with me. In North Carolina, actually, the Planned Community Act has no requirements to turn over control upon a certain number of sales of lots, but the legislature could have had that provision. The North Carolina HOA laws and condo laws are based on a uniform set of statutes that were drafted by what's known as the Uniform Law Commission. And they had recommended that for HOAs, there be a similar process to condos, but the legislature chose not to adopt it. So if you're unhappy that your community is controlled by a developer until the very last minute, blame the legislature. So what does it not mean? Well, it does not mean that the board can then take action that's adverse to a developer in a condo. No, you really can't impact the condo developer's ability to sell and market lots. It gives you the right to control the HOA, but or excuse me, the condo association, but you can't just do things that are adverse to the developer. In South Carolina, you guys may sometimes hear us HOA attorneys refer to South Carolina as the Wild West. And that is certainly the case with condos. There is a condo act. It's called the Horizontal Property Act, but it does not have any requirement to turn over control at any certain point. So if your documents don't give control to the owners, the developer could theoretically control it until the sale of the last unit. Anything you wanted to add, Mike?
Well, another reason the South Carolina's Wild West is they do not have a Planned Community Act whatsoever. So if you're a townhome or a single family community in South Carolina, there is no code of statutes that governs how your HOA functions, unfortunately. And so everything is governed by what is in your governing documents, your declaration of restrictive covenants and your bylaws, and that's unfortunate. Ben, I know there's been a Planned Community Act introduced a couple of times in the legislature down there. Any idea if there's anything pending or expected anytime soon?
I have not heard. I'm on the South Carolina Community Law Association or Community Law Commission, excuse me, which is part of the South Carolina Bar, and we get updates from legislative changes that affect HOAs and condos. And I haven't heard any updates for a while about any efforts to strengthen the HOA laws. So at this point, I don't think anything's coming down the pipeline. All right, so we've got some best practices here. As Mike, as you alluded to earlier, transition studies are very, very important. Transition study is basically where an engineering firm comes in and looks at the current condition of the common areas and advises on whether there is immediate construction needed. And the purpose is to try to catch any problems before the developer gets out of the community. In most communities, the board, a transitional board, or even sometimes a developer will have the authority to commission a a transition study. And that's very important. It tells you what's going on with your common areas and what urgent construction is needed. So something that goes hand in hand with a transition study that a lot of HOAs do not do is figure out what the HOA is responsible for. You got a lot of HOAs where once the developer hands it over, you've got a board that may not realize what they're responsible for. I've got a HOA client here in Charlotte where they have 13 detention ponds, which is quite a bit. And they thought they were responsible for 4 of them. And they had a big wake-up call once they realized we've got a ton of detention ponds that we didn't budget for and we didn't realize. So had they spent some time right on the front end determining what they were responsible for, they could have avoided that shock later on. So another thing that you as a board should do as a best practice is rely on your professionals. And that's your accountant, your engineer, your surveyors, your attorneys, your management company. I see a lot of communities that are in the transition phase where the members of a board or the committee are walking the streets and giving their own opinion about what needs work and what doesn't. And while that may be helpful, that's probably not going to meet the standards, the fiduciary obligations of a board member. And you can be assured that if a year from now the street needs work and the board said it didn't, then you're going to have some unhappy owners. So hire professionals and rely on them. You also should check in with an insurance agent right off the bat. The documents will oftentimes have unique insurance requirements that are specific to your community, and you need to be sure that you're meeting the requirements. You also need to be sure that you have a directors and officers insurance policy in place. And what that does is it protects a board if the board gets sued for a breach of its duties. And I'm going to leave some of this to Mike to add about insurance. He's much more of an insurance expert than I am. But Mike also advised that a board should have a standalone D&O policy that gives additional coverage that is not in the bare bones policy that a lot of insurance agents will recommend. One of the concerns, obviously, that we've touched on, and that is a big concern, is the condition of the common areas and what happens if the developer won't fix them. Well, in my experience, if you work collaboratively with the developer, you're likely to get more accomplished than if you're adverse to a developer. You don't want to spend a bunch of money fighting a lawsuit, either fighting the developer, trying to get them to fix something, or trying to locate a developer that's no longer around. You don't want to spend that money if you can work with the developer and just get it worked out. Some communities, if there's a big issue, have been successful in negotiating a transition agreement with a developer where the developer will agree at certain milestones and to a certain threshold to fix some of the common areas. So that's available in some communities where there's construction issues. Another thing that HOAs need to be aware of are whether there are statutes of limitation or statutes of repose. And what those are is a statute of limitation says you have to sue once you learn about a defect within 3 years. And a statute of repose says, regardless of when you learn about a defect, you have to sue within a certain time period. In South Carolina, you've actually got a longer time period. You can sue within 8 years of when construction is complete. In North Carolina, you only have 6 years. So basically, it's a drop dead date that says if you don't sue within that 6 or 8 year period, regardless of when you learned about a defect, you cannot sue anymore. So it's very important to try to determine what defects are out there, because if you wait too long, you may not have the right to sue at all. So one other thing that I didn't put on the slides, but it crossed my mind, at least in condos, is the transitional board or the new board, once it gets elected, should try to figure out if the amounts that are being assessed are correct. In condos, unlike in HOAs, you often have assessments that are based on what's known as the percentage interest. And that is an allocation to each condo unit that's based on a calculation in the declaration of condominium, or in South Carolina, the master deed. And what we've sometimes seen is in condos, you'll have people, every single owner, getting charged the same amount for assessments, but in reality, they're supposed to be getting charged different amounts. And if you catch it early, it's much easier to untangle than if you catch it years down the road. So that's something boards may want to consider. And that's all I have, Mike. Did you want to add anything?
No, there is a lot of confusion. Some condos do have voting rights and assessment obligations are equal for all units. Every unit gets one vote. Every unit pays the same rate. That's good in some cases, but in a lot of condos where you've got different with condos of all different sizes, usually the developer is going to set that up to where each unit's percentage interest in the common elements, which also translates to their voting rights and what portion of the assessments they pay, it's calculated basically on the square footage of the unit. So the smaller units pay less in dues, they have less of a vote. The larger units obviously pay more and they have more of a vote. And that's typically the more common way, especially where you have condo developments of units of all different sizes.
Hey, Ben, we have a couple of developer related questions. I know you're getting ready to go to a different topic, but what can a board do if the developer was given the bond back by the municipality, but is not turned over the roads?
Well, that's an interesting situation. A developer really, in my experience, developers don't really want the roads. Roads are a liability for most developers. So most developers want to get the responsibility over to the HOA or to the municipality. It begs the question of what is the developer's end game here? There may be a reason why the developer has retained control, and it may be a valid reason, but you probably need to explore why the developer has done that and have a discussion to try to figure out what is going on, because that's unusual. So it may help to have a discussion with the developer and see if they can get to the bottom of it.
Okay, next question. We have a transition committee that has been created, and the developer is not really interested in negotiating or responding to the committee. Is there anything that the committee can do to get the developer to respond?
Well, and that's a hard one, because you would think most responsible developers are willing to at least sit down and discuss, but some are not. And there's no real legal mechanism short of a lawsuit to make a developer sit down and discuss with the transition committee. What I tell transition committees and incoming boards is focus on the big ticket items. If you've got streets, for example, that are defective, that's what you need to focus on. Don't focus on making sure that your clubhouse is in pristine shape if it's really just wear and tear type of stuff. So focus on the big ticket items, because that's what's really important.
Okay, can you please address how an HOA could proceed when a developer and the declarant controlled board refuses to deal with warranties or warranted items until after the warranty period has expired?
Well, I probably need additional facts on that. Sometimes the warranty is basically automatically assigned to the owner once the owner closes on a house, for example. I don't know if that's the case or if it's something different. So I can't really answer that.
I don't know if I've ever heard of a developer giving a warranty on a clubhouse or some other amenity they build. That warranty obviously would be to the HOA. If you're talking about the home warranties that go with the homes, that's not actually a claim the HOA can bring on the owner's behalf. That's between the owner and the home builder or developer. But I mean, Ben, have you ever seen developers give warranties on the amenities?
No, I don't think I have. I typically see them in the sale of single family houses. You know, they'll give maybe a 10-year warranty on the foundation and, you know, a roof warranty, things like that. But I can't recall seeing it on the common areas.
All right.
Yeah, I've occasionally seen a warranty on a specific item within a clubhouse, where, let's say, the HVAC vendor installed, you know, a unit, and there's a warranty that's going to run with that installation. But you know, there's obviously your manufacturer's warranty and then the installer's warranty. So you sometimes have to figure out who holds the warranty and who's giving it.
Yeah.
What happens when a developer and the first elected board never did a transition study or a reserve study?
Well,
Oops.
yeah, you know, all I can say is get a reserve study as quickly as you can. Again, you've got these statutes of repose, either 6 years or 8 years. And if it's in South Carolina, if it's 8 years in one day, you may be out of luck. Say in North Carolina, 6 years in one day, you may be out of luck. So act quickly, try to figure it out.
So I guess, is the practice of a transition study, is that to be paid by the association or should it be paid by the developer?
Well, in my opinion, I think it should be paid by the association. And there may be differing opinions on that, but it's really to benefit the association. Now, if you could get a developer to pay it, great. I think a developer who is willing to pay it is probably one who's going to stand by their construction. But in my experience, it's usually paid by the HOA, although I would love if a developer offered to pay it.
Well, the other thing to consider also is the HOA wants the engineer's loyalty to be to the HOA, not to the developer. So if the HOA is the one footing the bill, his duties and loyalties lie with the HOA. The developer hires him, you know, the developer could potentially twist his arm and have an impact on what the results of that study show.
Yeah.
Okay.
Well, I'm going to jump to the next slide here. We can touch on some more transition related issues, but we'll try to move forward, and we may cover some of those questions as we go along. So after transition, what do boards need to do? Well, reserve studies, it's sort of the flip side of the coin. Rather than looking at the items in a transition study, which is really the condition of the common areas at a specific point in time, a reserve study tries to look forward and basically give the board an idea of how much they need to be collecting in reserves to replace the common elements at some point in the future. For example, roads and roofs, things like that, usually have a useful life, and the reserve study can tell you approximately when they'll give out. I don't know the exact timelines, but, you know, for example, a roof is usually 20 to 30 years, something like that. So a reserve study can help you budget for that. And in 20 or 30 years, theoretically, you should have enough money saved up as reserves to replace the roof. One thing that some boards brag about, and really it's not a good thing, but they say, well, we haven't raised assessments in 5 years. Well, shame on you. You should. That's setting yourself up for problems.
Yeah, that's not something to brag about.
No, it's not. Obviously, people are averse to raising assessments, but think about the difference between early 2020 and right now. You've got inflation of what, 15-20% between then and now. If you hadn't raised your assessments, you may be in trouble now. So you really need to be increasing your assessments over time. And there's also a practical reason, is that a lot of documents cap how much assessments can go up in 1 year. So a lot of them will say you can't raise assessments in a given year more than 5% or 10% unless you have a super majority vote of the members. Well, anybody on a board nowadays knows it is hard enough just to get 10% of people to come to meetings. If you need to get 2/3 of owners to come out and approve a special assessment or an increase to your budget, you're never going to get it. So if you're increasing your assessments over time, you can more easily deal with that situation. So those are the practical concerns. I also know of HOAs that have deferred maintenance for so long that now they're having to pass special assessments that are prohibitively expensive for their owners. In South Charlotte, for example, I represent a condo that's probably 40 years old, and they've got special assessments over the past 2 years. They're almost $20,000, and these condos probably sell for $120,000. So do the math. Most of those owners are going to have a lot of trouble paying for those special assessments. So you can avoid that if you're increasing assessments and maintaining your property over time.
In a perfect world, if you have professionally prepared reserve studies done by engineering firms that do that kind of thing, and you follow their advice and you properly fund your reserve accounts every year with a portion of your annual assessments, hopefully you'll never have to have a special assessment. Obviously there's always the possibility that there could be some serious damage that is not covered by insurance or something like that. But theoretically, if you plan properly, you should never have to have a special assessment.
Yeah. All right. So we're gonna probably breeze through this pretty quickly because I suspect a lot of the people watching this aren't living in condos, but it does affect those who do. Most people probably don't recall Fannie and Freddie, or at least they didn't up until 2008. If anybody that's 30 or older will remember that Fannie and Freddie had to get bailed out back in 2008 to the tune of, I don't know, $190 billion. What Fannie and Freddie do is they buy mortgages. So basically, if you walk into Wells Fargo, get a loan for your house, Wells Fargo, if they're meeting certain requirements, can sell that loan to Fannie or Freddie. And what it does is it puts money back in the bank's bank account, if you will. So basically, it creates liquidity in the mortgage market by giving banks more money that they can then go out and loan to someone else. So a lot of loans that are, quote, conforming loans, and by conforming, we mean that they meet Fannie and Freddie requirements. Approximately 60% of those loans are purchased by Fannie or Freddie. So it's a large number in the overall market. So as I think probably everyone will recall, in June of last year, horrible disaster. Champlain Towers collapsed, and that's just north of Miami. Terrible loss of life, but it caused a shockwave throughout the government and throughout Fannie and Freddie. Fannie and Freddie are not exactly government entities, but they were concerned by this, and the legislators started making demands, and ultimately, as a result of Champlain Towers, Fannie and Freddie came out with new requirements. So they came out with what they refer to as a supplement to their existing questionnaires. And it went into effect, to all of our surprises, in January of this year. They had talked about it previously and put it off, but then all of a sudden it hits in January. What it says is that condos now have to meet new additional requirements to be able to have conforming loans. One of them is that there cannot be significant deferred maintenance. There can't be unsafe conditions. You have to set aside a certain amount each month or each year for reserves. It's 10% is the threshold. You may be able to get around it, but it's typically 10%. The requirements for Fannie and Freddie are almost identical, and they use the same questionnaire. So if someone wants to have a loan that it ends up getting sold to Freddie or Fannie, it's basically the same requirements. So there are some red flags that probably disqualify a community from being able to have conforming loans. One of those red flags is if there is deferred maintenance that will require a building to be evacuated for 7 or more days. You've also got a red flag if there are what Fannie and Freddie refer to are Deficiencies, defects, substantial damage, or deferred maintenance, which affect the safety, soundness, structural integrity, or habitability. And that, as you can imagine, is a pretty broad category of items. If you've got failed safety or inspection reports, that's a red flag. Also note that some boards may have had to deal with FHA approval. FHA and Fannie and Freddie are different. They're somewhat similar in what their requirements are, but FHA does loans that have a very low down payment requirement, as low as 3.5%. And Fannie and Freddie are not quite those loans. They are really more traditional lenders with a higher down payment, but they've got a lot of similarities. But if you are a condo association that meets the FHA requirements, you still have to comply separately with the Fannie and Freddie requirements. So what do condos have to do now to comply? Well, they've got to provide documents that Fannie and Freddie are requiring banks to review. It's things as basic as your declaration of condominium or master deed if you're in South Carolina, your financial statements, your reports from architects, engineers, your reserve studies, your budget, attorney opinions, appraisals, all kinds of things. And these are all in addition to the questionnaire that is now required. The questionnaire itself has some very pointed questions. They're hard for HOAs to answer. One of them is, when was the last building inspection by an architect or an engineer? For some condos, it's been a while. You have to also represent as the board if there are deficiencies that affect the safety, soundness, structural integrity, or habitability. And then you are supposed to have had a reserve study within the past 3 years. So that's pretty frequent to have reserve studies every 3 years. I don't know that all communities have historically done them that frequently, but that's now an added expense. So here are board concerns and maybe best practices for boards to consider. As a board, your duties are to your owners, your current members. It is not really a duty to future owners. So one thing is that some boards need to decide if they're even willing to fill out these questionnaires, because potentially you're exposing your current owners to liability if let's say the questionnaire is incorrect for someone that's not even a member. You're basically you're providing a service to a future owner in many respects to the detriment of current owners. But you have to be worried whether, if you're not complying with these new Fannie and Freddie requirements, will that affect the sellability of your current owners for them to be able to sell their units. I created a word here, unsaleability. But basically, if you get blacklisted on the Fannie or Freddie websites because they keep a database, is that going to negatively affect the ability of owners to sell their units? Well, we don't know, but it might. So a few pointers that we think are helpful. The board, if it can, should defer to the architects and engineers rather than making an affirmative obligation. If you've got a reserve study, provide that to the lender. Don't go out on a limb and say, well, we interpret the reserve study as follows. Give that to the lender, let them make their own determination. Second, if the board doesn't know an answer, say so. Where boards could get into trouble is if they are representing that a certain condition is not dangerous or that the property is in a safe condition. And if the board doesn't know, they shouldn't come out and say that. So those are a couple of pointers that boards should probably consider, given that this law is this change in Fannie and Freddie is so recent. We don't really know how strictly these supplements will be interpreted by Fannie, Freddie, or ultimately by our courts.
And these questionnaires just took the community association industry really by surprise, because they just sort of came out of nowhere and were just dropped in January like a bomb. And a lot of the management companies have just said, we're not filling these out because they could be liable if they misstate something. If you do want to answer the questions as a board, you need to be sure you preface your answers with the words "to the best of the board's knowledge, comma, there are no unsafe conditions." And you might be able to get some engineers to come give some opinions or answer some of these questions, but they're only going to do that if they have come out and inspected the buildings. They're not going to give an opinion off the cuff. But the Community Association Institute has been pressing Fannie Mae and Freddie Mac to suspend these new rules until they can go back and reevaluate how they're being applied and how onerous these rules are, because a lot of condo associations and a lot of management companies are just saying, sorry, we're not going to answer these because we don't want the liability. And I don't blame them.
Well, and I'll add, Mike, it's not that we don't or can't, or in most cases, we can't answer the questions, right?
Right.
We don't have that experience, that knowledge, that information. But
exactly.
in most cases, the boards don't either. So that's where we need to rely on the experts.
Exactly.
So one of the questions that came in is, what are the risks if the board doesn't want to answer these questions, the management company can't answer the questions, we may not qualify for Fannie or Freddie. Is there risk by not being able to meet a conforming loan?
Well, yeah, because it may shrink the pool of possible buyers. But ultimately, that's for the board to decide. What's worse, not having as many possible buyers or as many lenders, or exposing the board or the HOA to significant liability if something's wrong. You kind of got to weigh the risks.
Yeah, and it's like so many things in this business. It comes down to a balancing of risks. Is the risk higher to the HOA to answer these questions, or is the risk higher to refuse to answer with the possibility that an owner who has lost a potential sale sues the HOA? I mean, there's nothing in the statute that says the HOA has any affirmative obligation to answer these questionnaires, but the board does have a fiduciary duty to act in the best interest of the owners, and trying to get these condos qualified for Fannie Mae and Freddie Mac mortgages obviously is in the best interest of owners, but it comes down to just a balancing of the risks, and that's a very subjective matter for a judge or a jury to decide. So
I'll ask, in your opinion, is it better for the board? Obviously, the best answer is going to be have an expert provide the necessary information.
Yeah, that's the best way. If you are going to do it, I think that you should probably have an engineering study done of the building, and then instead of answering the questions, just say, here's our engineer's report. You make of it what you will, and see how that goes.
So, but in your opinion, the risk is very low back to the owner, and the risk of an owner suing because you haven't been able to provide a conforming loan versus the liability of answering a question incorrectly?
We don't know. This is also new. There hasn't been time. Obviously, it's only been in place for 3 months. There hadn't been any. The only way we'll have any law to guide us is if some lawsuits get filed, they get decided at the trial level, then they make it up to the appellate courts, and the appellate courts make some decisions and start publishing those decisions. Then we'll have some guidance. But until that happens, we have no idea.
So if a lender is saying you must answer these questions, and we say we can't, and I say we in board and management company can't, are we just at a stalemate, or where do you go from there?
Well, I mean, they can't make you answer it. Here again, as Ben Karb was saying, the board's duty is to the current owners, not to prospective purchasers or their mortgage lenders. The board owes no duty to those people. The duty you owe is to the current owners.
Yep. And so the best practice, again, is to hire that engineer, but if you can't, you answer the questions as much as you can.
Right. To the best of your knowledge.
Yeah. And there's going to be a lot of engineers making a lot of money in the next couple of years.
Yeah.
But I know CAI is lobbying hard on this one, so hopefully we'll see some movement and get clarity, because there's tons of questions around this topic from both board side and management company side.
Right. I see one of the questions is lenders say you must answer all questions. No, you don't have to answer the question. You don't have to answer any of them. Here again, you don't owe any duty to a prospective purchaser's lender, none whatsoever.
Yeah, and frankly, that purchaser could go out and find a different lender. I mean,
Exactly.
a lender right now, or at least up until the last couple of months, loans were easy to get. So you could shop around and get good loan terms, and at tons of different lenders out there who probably don't have loans that they're selling to Fannie and Freddie. So there are other lenders.
Yep.
All right. Well, this is my last substantive slide. I'll be real quick. There's just a couple of cases that I thought were interesting. One is in North Carolina. Well, actually, let me back up a step. I didn't include this in the slide. I meant to, but North Carolina and South Carolina say that sellers of real estate have to provide a disclosure to buyers. And it basically says whether the seller has knowledge about any structural issues, construction defects, leaks, things like that. And the seller has the option of saying, yes, I know, no, I don't know, or making no representation. So it's designed to give a buyer the ability to do some research from the seller if the seller is willing to provide that information. We have a case here in North Carolina, at least, that says even if even if a seller has affirmative representations on this disclosure form, that the buyer still has to do some diligence. Reasonable diligence is the word that the court used. So they can't just blindly rely on a seller's representations. In South Carolina, we don't really have a similar case, but we do have a case that's a little bit troubling where a seller got in trouble for failing to disclose that the condo association was a party to a lawsuit. And the court basically said, yeah, this is something a buyer would want to know. You had a duty to disclose it. I've got some problems with that case, but anyway, it's good law right now, and a seller has to disclose things like lawsuits, even if they could be discovered by a buyer, and they should have been discovered by the buyer. But a seller in South Carolina has some additional disclosure obligations. So that is all of our slides. We can move. Obviously, we've been answering some questions, but we can fully go to Q&A.
And I'll ask one question. Y'all commented on South Carolina Planned Community Act, and I guess they did adopt something about 3 years ago, if I remember correctly. It had 6 sections. Is that not technically a Planned Community Act, or is that?
Well, it's the South Carolina Homeowners Association Act, and really all it does is it requires a HOA to record governing documents, and it's very broadly defined. It's your declaration or master deed, which should be recorded, but also your bylaws, your rules and regulations, things like that, so that a purchaser can locate them if they want to research it. Or an owner could go out and do a title search and get those documents. It also establishes basically a way to make complaints against HOAs or condos or management companies, for that matter, with a South Carolina agency, but it has almost no teeth. You can make a complaint, and that's it. If the HOA or condo doesn't want to respond to the complaint, they really don't have to, but it's a public record if someone makes a complaint. So it really doesn't change the substantive law, other than saying you have to record documents in the Register of Deeds, and it gives people the ability to complain publicly. That's all it does.
Okay. Well, I don't see any more questions that have come in. I guess we'll give it another 30 seconds.
I've got a last volley of lawyer jokes if you want to hear those.
Please.
Well, why do they bury lawyers 10 feet in the ground instead of just 6?
I don't know.
Because deep down, lawyers are good people. What's the difference between a lawyer and a jellyfish? One is a spineless, poisonous blob. The other is a form of sea life. What do you call a lawyer with an IQ of 100?
I don't know.
Your Honor. What do you call a lawyer with an IQ of 50?
I don't know.
Senator.
Hey, we do have another question that has come in. So are there consequences? And I guess this would be more about liability, but if those questionnaires are not accurate or false with those statements that are made, and what are the repercussions?
Well, the law is so new that we don't necessarily know what the repercussions are, but you can be assured that a lender that buys a loan that is subject to a misrepresentation, for example, that lender is going to sue, and they're going to sue as many people as they can, because ultimately there's money on the line and they want to find somebody that's willing to pay them for the misrepresentation. So there's going to be lawsuits. We don't exactly know how punitive they will be, but you can be certain that lenders will sue if there's a misrepresentation.
So, will Mike, any more jokes?
No, you got all my good ones.
All your good ones.
What's the difference between an accountant and a lawyer? The accountants know they're boring.
Okay. Well, okay. Last question. If a declaration calls for a declarant to give up control of the association on a certain date, can the declarant issue a new declaration moving that date out further? I'd say as long as they have the ability to move that date. But Mike,
Yeah.
Ben.
I've seen that happen. A lot of times you see declarations that say the declarant control period runs through X date or until 90% of the lots are sold, whichever is later. And a lot of times the developers put language in there that says that during the declarant control period, the developer can amend the declaration by itself without any vote of the members. And so if they see they're approaching that deadline for turnover and they realize they're not far enough along as they thought they would be, if they have the right language in their declaration, they could file an amendment to the declaration, pushing that turnover date out. So yes, it's possible, but only if the document allows them to do that.
Yeah, and we saw that a lot more in the basically 2010 to 2015, because
Right.
you had a lot of subdivisions that
went belly up
right in 2008, and they couldn't sell lots, so they had to push the control date back. But we don't see it as much anymore, but you occasionally still see developers doing that.
Okay. Well, Mike, Ben, thank you very much. I guess until next time. So we, again, thank you everybody for joining us this evening. This recording will be posted on the CAMS MGT website under the webinar section. So we hope you'll let your other board members know that you can visit that place and get all this great information. So again, thank you and good night.
I did see one last question pop up, and the
Okay.
question was, does CAMS provide reserve studies? And the answer to that is no. There are reserve specialist firms that do that. They're basically engineering firms, and they have qualified engineers who go out there and look at the streets. They'll do core drilling on the streets. They'll examine the clubhouse, the foundation, the whole infrastructure and everything to make sure everything was built according to plans and is free of defects. But no,
Yep.
The management company does not provide that, but they can certainly put you in touch with a reserve specialist.
Yep, absolutely. Absolutely. Okay. Well, thank you again and good night.
Thank you for having us.
Thanks, everybody.
Bye-bye.